I actually can't see when the number of people on the.
If you hover down at the bottom, it looks like we have 11 people here.
Oh, great.
12. Do you want to start an intro?
We're gonna wait till 5 after, just to let
Okay.
people trickle in. You could still see my screen, right?
Mm-hmm.
Oh yeah,
Sure.
okay, yeah, 18 people. All right, so yeah, we're just gonna wait till 12:05 and then get started.
Yeah. So we got a lot more people we expect to log on here any second. – 25 people here now, so we'll wait another 2 minutes.
Dana, the screen you see, it's just the PowerPoint, right?
Yes.
Okay. So I'll go ahead and start in a minute. It's at 12:04 now.
Perfect. I see a question coming into the chat box, but I think we're gonna address questions in the end, right, Veronica?
Yep, we'll just keep track of the questions and address them at the end of the presentation.
Perfect.
All right, so it's 12:05, so I'm going to go ahead and get started with today's presentation. We wanted to allow some time for people to tune into the Zoom webinar. So good afternoon. My name is Veronica Williams, and I'm a lead attorney with Legal Aid Society of San Diego's Social Security Advocacy Program. Thanks for spending your lunch hour with us and learning about the basics of applying for Social Security. Before we begin our presentation, I wanted to give you some background about our program. Our program is dedicated to helping vulnerable San Diegans with obtaining Social Security. We provide a range of services ranging from filing initial Social Security claims at local Social Security offices to representing clients in federal court. In addition to meeting with clients at our legal aid offices, we have advocates that are stationed all throughout the county. We have advocates at 5 family resource centers and 6 county mental health clubhouses where they help people with Social Security claims. We also have a children's Social Security program, which we'll talk about more in our presentation. And again, at the end of the presentation, I'll give you further information about our program as well as our contact information. So I'm going to start off today's presentation, and I'm going to pass it on to another legal aid attorney, Deane. We both have experience representing clients at all stages of the Social Security claims process, including representing clients at administrative law proceedings, as well as representing clients in federal district court. So I wanted to give everyone a roadmap for how we're going to manage today's presentation. First, I'm going to go over the Social Security program types and eligibility requirements. We're going to talk about Social Security's definition of disability. We're going to talk about the Social Security application and appeals process, the impact COVID-19 has had on the application appeals process. And we're also going to share with you information about Legal Aid Society of San Diego, including our Social Security Advocacy Program. We only have an hour, so we're going to be scratching the surface on a lot of these topics. We have a lot of ground to cover, but we're going to make some time for Q&A. But if we're unable to answer every question, or if you'd like further help, we're going to provide you with our contact information so you could get a hold of us. And lastly, just as a bit of housekeeping, at the end of our presentation, you're going to receive a link to a survey so you can provide feedback to the San Diego Law Library and as well to our offices so we could get guidance and your impressions about the presentation. So please hang around a little bit longer after the presentation so we can so you could take our survey, okay? So I'm going to go ahead and begin, okay? We wanted to start first by providing a basic understanding of the term Social Security. The term Social Security refers to 2 distinct programs with different eligibility requirements. So now I'm going to go over the types of programs and what you need to do to be eligible for the programs. So again, there are 2 distinct benefit programs. There's Supplemental Security Income, also known as SSI, and there's also Social Security Disability Insurance, also known as SSDI. So I'm going to start first with Supplemental Security Income, or SSI. This is a program that's a federal cash benefit that's based on need. It doesn't matter whether an individual has worked in the past or not. There are some states like California where the state government supplements the amount of federal cash that people are eligible for. To be eligible for SSI, you must meet both the categorical and general eligibility requirements. In other words, you have to fall into certain categories. You must be disabled, over the age of 65, or blind. And we're going to go over what that means just in a moment. You also have to meet certain general eligibility requirements. Since this is a program for individuals with limited income and resources, there are certain income and resource thresholds that you must meet. There are also residency requirements and citizenship requirements. So I'm going to talk first about the different categories that you have to fall into to become eligible for SSI. So first, you must fall into one of 3 categories. You must be disabled, and definition of disability. Just briefly, we're going to go into this much further later on the conversation or in the presentation. But a disability is a severe medical impairment. It could be physical or mental that has lasted or is expected to last for 12 months continuously. You could either be aged, and this is someone that's 65 years age or older. You have to be a US citizen, and legal permanent residents are also eligible if they're disabled. Another threshold or requirement where someone would be categorically eligible for SSI is if they're blind. And Social Security's definition of blindness is 20/200 corrected vision in the best eye or extremely limited field of vision. Again, supplemental security income is a need-based program. Because of this, there are certain income requirements that you must meet. You may only be eligible if your income doesn't go over a certain amount of money per month. And this amount is based on a rate set by the federal government. The rate changes from year to year. For 2020, the rate is $783 for an individual and $1,175 for a couple. If your income is equal to or less than the federal rate, you may be eligible for SSI, but your benefit amount may be reduced based on the income amount. So I wanted to talk now about what is considered income, okay? So Social Security treats income sources differently. And the way they define income is anything one receives in cash or in kind that can be used to meet basic needs for food or shelter. And so there are three categories of income. There's unearned income, earned income, and deemed income. Unearned income, this includes all income except wages. So this is state disabilities, workers' compensation, Social Security benefits, pension dividends, rent, gifts, in-kind support and maintenance. There's also earned income, which, as the name suggests, this is income that you receive through work. And there's also deemed income. And this is the income that certain persons like a spouse, parents, or sponsors may receive, and that may be included in the calculation of the accountable income that's available to you and part of an applicant's income. So again, Social Security will factor your income, if any, when determining whether you're eligible and how much SSI you may receive. Second, again, since SSI is a needs-based program, it's for people with limited income and resources. Social Security defines a resource as any cash or liquid assets or any real or personal property that can be converted into cash to be used for support and maintenance. There is a maximum resource level. It's $2,000 for an individual and $3,000 for a couple. And if you're over this resource amount, then you will not be eligible for SSI. However, there are some exceptions. So the exemptions to the resource requirement include a house if you're living in it, one car if you're using it for personal transportation, and life insurance, burial spaces, and burial funds. Likewise, if you have a resource, for instance, a house or a car, and you transfer it at less than fair market value 3 years prior to or during or after you apply for SSI, it may result in you being ineligible for up to 3 years. So next, in order to receive SSI, there are additional residency and citizenship requirements. You have to be a resident of the United States, and you either have to be a US citizen or a lawful permanent resident who either lawfully entered the US before August 22nd, 1996, or lawfully entered the US after August 22nd, 1996, and meet certain exceptions. You'd have to have 40 quarters of covered work, be a refugee, or have political asylum or other immigration related exceptions. So next I wanted to provide you all with a table. I'm not going to go through each and every field, but just to give you an idea of what the SSI benefit amounts are for 2020. Just generally, the federal payment that one receives for SSI is determined by recipient's income, living arrangements, and marital status. So as you could see in this table, if you're 65 years old or older, the maximum amount of SSI is $943.72. And for couples, it's $1,582.14. And these benefit amounts, again, vary depending on, if you're living alone, if you're living in the household of another person, whether, say, you're, independent and don't have access to cooking facilities, or if you're in a board and care living arrangement, okay? And the last thing I wanted to point out on this page is that the 2020 substantial gainful activity rate is 1,260. And my colleague Dana is going to talk more about what that means and the significance about that of that amount. But I just wanted to include that here just for your knowledge, okay? So next I'm going to talk about Social Security disability insurance. This is the second type of Social Security program that people might be referring to when they use the word Social Security. So you could think of Social Security disability insurance, or SSDI, as a federal cash benefit based on work history. And this is because benefits are paid based upon an individual's Social Security earnings record. There are other two program types within the realm of SSDI: disabled widows and widowers benefits, and disabled adult children's benefits. But today we're only going to be focusing on benefits available to disabled workers, okay? So just like SSI, you have to fall under certain categories to be eligible for SSDI. You must be disabled, be over 65 years old, or blind. And the definition of those are the same for SSDI. However, unlike SSI, there's no income or resource limits. Benefits are only reduced, say, if one is receiving workers' compensation, state disability insurance, or any other government disability benefits. Again, there's no limit on the resources you may have. So you can have more than one house. You could have a house and 2 cars. And the residency requirements are different. U.S. citizens can live in the United States or another country, and non-citizens who are lawfully present in the United States can leave for up to 6 months. They must come back to the United States for 30 days to resume benefits. So I'm going to talk next about the work requirement, which is another distinction between SSI and SSDI. So first, you must have worked 20 out of the 40 quarters before the date you became too disabled to work. And this is what's known as an onset date. All right. And you also need to have worked at least 1 quarter every year after the age of 21. And a quarter is considered a 3-month period in which you're at least making $1,410. And this is the amount as of 2020. If one has a disability that began before the age of 31, the rules are a little different. You need to have worked 1/2 of the quarters between age 21 and the date you became disabled. And this is also known as the onset date or onset of disability. Now I'm going to just touch briefly on the exception for disabled adult children benefits. And these benefits are available to individuals where they became disabled or their onset date of disability was before the age of 22. And they have a disabled, retired, or deceased parent who worked enough credits to be eligible for Social Security benefits. So in other words, your eligibility would be dependent on whether a parent worked enough credits to be eligible for SSDI. So now I'm going to pass the presentation on to my colleague Deane, where she's going to talk about breaking down the Social Security's definition of disability.
Hi everybody, I'm Deane. As Veronica said, I am a staff attorney on the Social Security team with Legal Aid Society. I work with Veronica, and I am just gonna share my screen here for my portion. Okay, can we see my screen now, Veronica? Yeah?
Yes.
Perfect, thank you. Okay, so yeah, so like she said, I am going to delve a little deeper into what disability means under Social Security rules and kind of walk you guys through the application process as well as appeals after initially applying. So, okay. Oops, sorry. I was trying to minimize my thumbnails here and instead I minimized the other thing. I'm trying to see my thumbnail. Okay, there we go. So Social Security's definition of disability can be broken down into multiple parts. So basically you cannot be able to engage in what's called substantial gainful activity. And that's a term that Veronica used a few minutes ago in her presentation. We'll talk a little bit more about what that means in a second. Meaning you can't earn, you have to have the ability to not earn a certain amount of money. By reason of any medically determinable physical or mental impairment, which can, and this impairment has to be expected to result in death, or if not, it has to have lasted or be expected to last for a continuous period of not less than 12 months. Okay, so we'll break that down bit by bit. So inability to engage in substantial gainful activity. Now, substantial gainful activity means that basically means work for pay or profit, and you do not have the ability to perform the basic, significant physical and mental work activities to perform a job. And they kind of assign a figure to that, which, as Veronica mentioned earlier, was $1,260 for 2020. It generally goes up every year, like with inflation or something. So basically what they're saying is if you have the ability to earn more than $1,260 in a month, then they're going to assume that you're not disabled because you have that ability to earn that much money. So you must be working enough. Roughly speaking, we sort of equate substantial gainful activity to full-time work, the ability to work full-time. Although that's kind of simplifying it a little. It's a little more complicated than that because under certain circumstances, part-time work can be considered substantial gainful activity, and even volunteer work can be considered substantial gainful activity based on varying circumstances that are kind of too detailed to get into this overview presentation. But yeah, $1,260 a month is sort of the cutoff there. Now it's not just your inability to do work that you used to do in the past, okay? It's inability to do any type of gainful work, no matter if you have experience in it or not. Social Security does recognize various factors, though, that can hinder a person's ability to do a job, such as your age, your education, and the work experience that you do have. So by reason of impairment, this means that you have to qualify for SSI or SSDI based on an actual physical or mental disability, not for any other reasons. It's not that you can't find a job because, you experience discrimination, for whatever reason or if you have a criminal background and it's hard for you to find a job, or if the economy's bad and you can't find a job, or if you don't have the experience that, employers are looking for. That doesn't matter. It's, do you have a physical or mental impairment that prevents you from being able to work? So it's a question of, are you employable despite the impairments that you have? So medically determinable. This means that it has to be determined that you do have this physical or mental disability based on objective medical evidence, which usually means your medical records. Medical records can come from various sources. You know, it can come from your primary care provider. It can come from various specialists who deal with your particular issue. It can come from hospitals, crisis houses, even if it's a mental health disability. And the types of records can include all kinds of things. It can be progress notes, lab results, diagnostic imaging tests, x-rays, MRIs, things like that, therapy notes from your therapist or psychiatrist, medication lists, things like that. Now, whether or not you have a disability and are able to work or not, that's not going to be based on the statements of other people, including your doctors. We have a lot of clients that, you know, will sort of get frustrated and say, why did they deny me? My doctor said I'm disabled and I can't work. Well, Social Security's position on this is, you know, frankly, oh, well, we'll be the judge of that. Okay. So just because your doctor says you're disabled and can't work doesn't mean Social Security is going to agree. So it has to be based on the actual objective medical records in your file. And I do want to point out this sort of all caps and bold statement at the bottom of the slide here that says medical treatment is the single most important factor in a disability decision. And that is absolutely true. You are going to have a very, very hard time getting approved for disability benefits if you are not in treatment for your conditions. If you're not seeing, you know, if you haven't been in treatment for over a year, you haven't seen a doctor in over a year, you know, you've been getting referred to specialists, but you're not following through on making appointments for those referrals, or you are constantly not showing up for your appointments, or you're not taking the medication that's prescribed for you, that's really going to hinder your ability to get benefits, because Social Security's position is, well, if you followed through with your treatment and you took your medications as prescribed or whatever, then maybe you wouldn't be as bad off and you might be able to work if you just followed your doctor's orders, sort of thing. So medical treatment is extremely important. Now, continuous period of not less than 12 months. Again, this does not mean inability to find work for 12 months just because you've had a hard time finding a job. It's the actual existence of an impairment for a continuous 12 months that prevents you from working for that long, at least that long. And by continuous impairment, of course, we mean it has to be ongoing. It's not just, you know, periods of impairment where you're perfectly fine for a few months and then you have sort of backslide for a few months and then you get better. You know, it has to be sort of a continuous thing. Okay, so now I'm going to talk about the actual application process and the appeals. So here's an overview of the whole application cycle. You start with the initial application, of course, and it can take about 3 or 4 months before you get a decision on that application, because what Social Security is doing at that point is they are gathering your medical records and reviewing them before they make a decision. About a third of applications are approved at the initial level, but that means about 2/3 of them are not and are denied. So then if you want to appeal, then you ask them to reconsider their initial denial. Again, that takes a couple of months too, because again, they're requesting more records and reviewing them. Very little, unfortunately, cases get approved at the reconsideration level. Only about 11%, 10%, something like that. And we'll talk a little bit about why in a second. If you're denied at reconsideration, then you can appeal and ask for a hearing in Social Security court in front of an administrative law judge. And to shorten that, I'm going to refer to them as ALJs from now on. Now, this is a very long part of the process, unfortunately, because the hearing offices are so backlogged. It can take about 1 year to 1.5 years after you request a hearing before you actually show up in front of a judge. But Most cases are approved at the ALJ hearing level, about 48%, so that's almost half. However, if you're denied by an ALJ, then you have the chance to appeal that decision, where you then appeal to what's called the Appeals Council. This is one appeals office that's located in Falls Church, Virginia. And I guess because there's only one appeals office hearing every appeal from around the country, it can take a long time to get a decision from the Appeals Council, about 1 to 2 years. In my experience lately, it's been about a year, but it can take even longer than that. So we tell people up to 2 years. Only about 18% of those cases result in some sort of favorable decision. So if you are denied at the Appeals Council level, you then have the option of going further, appealing further to federal court. And what this means basically is suing the Social Security Administration in federal court. And there, at that level, a lot of cases will get favorable results. About 44% are granted by the federal judge or get some sort of favorable decision in some way. Now, that said, this whole long timeline is for your standard Social Security, disability, or SSI case. There are mechanisms for expediting cases so that they go quicker. As you see on the square on the side here, there, for example, there's the Compassionate Allowance Program, the Terminal Illness Program, and the Presumptive Disability Program. All of these programs are sort of similar in that each one of them requires that your disability be so severe, you know, that it becomes pretty obvious to Social Security that you really can't work, and they don't need to make you jump through all these hoops to prove it. So Compassionate Allowance Program, you know, there's a whole list of certain disabilities under the program, such as various types of cancers and things like that, that if you meet the diagnostic criteria under them, they will allow your case. Terminal illness, it's the same sort of thing, but with the addition that you have a terminal illness and you need to get a decision on this case before time runs out for you. And then Presumptive Disability Program, again, this is examples of very severe disabilities, such as, for instance, you have your leg amputated at the hip, or you are confined to a bed, or you have an intellectual disability that's so severe that you basically can't take care of yourself at all. You can't feed yourself, you can't dress yourself, you can't bathe yourself, things like that. Then Social Security will presume you are unable to work. Okay, so starting with the initial application, there are various ways that you can file one. Typically you can go in person to any Social Security local office and ask them to fill out an application, and they will help you do that. That, however, is not really the case right now during the pandemic, but typically you can. You can also call them and they will do a telephone interview with you to complete an application and the various disability reports and things that go along with an application. And you can also file online at ssa.gov. However, it's only the SSDI, or Social Security Disability Insurance application, that can be filed online. The SSI application, the needs-based program for supplemental security income, that cannot be filed online. So you have to, probably call and fill out the forms and mail them in and whatnot. So. Okay, so who is deciding whether or not you get granted? Well, in every state, Social Security contracts with a state-run office called Disability Determination Services Division. They contract with various analysts and doctors, physicians, specialists, psychiatrists, whatever, to review records for an application and make a decision. So in California, our Disability Determination Services Division is handled by the Department of Social Services. There is an office located in San Diego. And when you submit your application, your case will be assigned to an analyst. And this person is not necessarily a doctor, but they are trained in, Social Security law, and they will work up your case. They will, send you any additional forms that need to be signed, such as, a work history report if they need more information about your past jobs, things like that, or various questionnaires about your disabilities. They will then also request your medical records from all your doctors, because with your application, you're going to submit basically a list of all the doctors that you see for your conditions. If necessary, if they feel that they don't have enough information from your records, they will also schedule what's called a consultative exam for you, which is where they schedule an appointment for you with one of their doctors. Now, these doctors don't necessarily work directly for Social Security. They are like their own independent practices, but they are paid by Social Security to do these independent medical exams. And they will issue reports of the results of the exams to the Social Security Administration to help Social Security make a determination on your case. And so once all the information is gathered, then the analyst will consult with an actual medical, provider, a physician or a specialist, or, psychiatrist, psychologist, if it's a mental health issue. And together with the doctor who will have reviewed all your records, they will make a decision as to whether or not you meet the definition of disability under Social Security rules and issue a denial or an approval. Now, the application can take an average of about 3 months or so before you get the decision. If it's favorable, great. They will let you know. They will call you. And they'll send you a letter in the mail. And then all you have to do is contact them and set up your payments. Now, you have a year to do that. So it's very important, that you're keeping them updated with your phone number and mailing address, so you get this correspondence telling you that you won. Because if you don't get your payments set up within a year after the decision, you'll have to start all over again. If it's an unfavorable decision, they will send you a written notice saying that they denied it for various reasons, and then you can appeal and ask them to reconsider the decision. Now, you have to file that appeal within 60 days. Generally speaking, they will give you an extra 5 days for mailing, but yeah, just remember 60 days is sort of the magic number there. You gotta appeal within 60 days. You can file an appeal online at ssa.gov, or you can go to your local Social Security office and tell them you want to appeal. Okay, so reconsideration. This process is the same as what you go through for the initial application as far as how they evaluate, but it goes to a different analyst who didn't make the prior decision. Now, the approval rate is very small, like about 10% or so, because typically the new analyst will just sort of uphold the initial decision, unless you can show them that something has changed since then. And so it's important, in order to have a chance at getting your case approved at the reconsideration level, that you provide them updated medical records, or let them know, that there are updated medical records that they can request those records, or if you have new providers or whatever. But yeah, it's very important to submit new medical evidence on reconsideration. Otherwise, they will have no reason to change the initial decision. So you want to allow enough time, for you to gather those medical records, those new medical records, and submit them. All right, so the decision on reconsideration, depending on how much new information is shared, can take just a couple of weeks, or can take up to a couple of months. And same thing, if it's favorable, you just have to contact them within a year to set up your payments. If it's unfavorable, again, you'll receive a written notice, and you have 60 days from the decision to appeal and ask for a hearing in front of an administrative law judge, or ALJ. So, administrative hearings. This is handled by what's called the Social Security's Office of Hearings Operations. Now, typically, after you request a hearing in front of an ALJ, they will send you a letter basically saying that they will schedule your hearing as a video teleconference hearing, where under normal circumstances, you would go to your local Social Security office in person, and they would put you in a room with a big TV screen where you will then see a judge on the TV, and this judge, and they will see you too through a webcam and audio and whatnot. and you are basically speaking with a judge that is out of state, you know, usually in Albuquerque, New Mexico, or they can be in other states too. So they are not local judges. And however, that notice that you get of the video hearing gives you a right to object to it and ask for a hearing in person instead. Now, you only have 20 days after you get this notice to object to the video hearing and ask for an in-person hearing. So it's important to you know, keep up with your mail and those deadlines. Now, and yeah, and if you object to a video hearing, that just means you will go to your local San Diego Social Security hearing office and be face-to-face with a San Diego judge. So, yeah, so like I said, waiting for a hearing though can take a very long time, about 12 to 18 months after you request a hearing. And then once you have the hearing, you got to wait some more because it then usually takes about 3 months or so after the hearing before the judge mails a written decision. Typically this is because, you know, they're very backlogged at the hearing office and they have to write pretty long, very detailed decisions. So again, you can request an expedited hearing under certain circumstances that, you know, mark your case as critical. For instance, if you have a terminal illness and you need to get a decision right away, then they will expedite your hearing request. Or if there's some other kind of dire need, for example, if you are actively suicidal, they might try to hurry up your hearing. Or if you're homeless, meaning you're actually living on the streets, then they will try to expedite it. On an expedited case, they will normally try to schedule your hearing as best they can within about 3 months or so, I think. Now, it's important to know that you have a right to a representative at this hearing. If you show up without one, the judge will normally ask you in the beginning, do you want to get an attorney? And then they will postpone the hearing if you say yes. Now, you know, this can be an attorney. It can even be a non-attorney that can represent you in front of an ALJ. However, of course, we would recommend an attorney who is, you know, very familiar with Social Security laws. And you do have the right to change your representative for any reason at any time. Now, the format of the hearing usually takes anywhere from 30 to 60 minutes, maybe generally about 45. And the people who are present are typically you, your representative, the ALJ. There's usually a hearing monitor, you know, typing a hearing transcript of everything that everybody's saying. There could be any witnesses that you want to bring to testify on your behalf. And almost always there is a vocational expert. And that person is an expert on jobs. And a vocational expert is there to do a couple of things. One, to classify for the judge the type of work that you used to do. They classify it sort of in terms that the judge can understand. And they are also there to answer the judge's questions about whether or not someone with your specific limitations could either return to the type of work that you used to do in the past, or if not, whether there's any other type of job out there that you could do with your limitations. And then there also might be a medical expert there. This is less common, but there definitely have been, plenty of medical experts at hearings. Typically, if the judge isn't really sure whether you meet the diagnostic criteria for a certain condition, or isn't really sure just from looking at the records, what your limitations are, or if you have some kind of unique disorder or complex disorder, then they will call a medical expert to testify to get the expert's testimony as to what they think your limitations actually are. And so the format of it is, you will get questioned. You will be doing most of the talking. Your attorney can do some of the talking as far as making arguments, and they will get to question you too. But for the most part, the judge will want to hear directly from you, where you will answer their questions about your work history and the types of job duties you used to have. And then they will ask you specifically about your medical conditions. For instance, What symptoms do you experience? Have you had surgeries, things like that? And how those impairments have affected your daily activities and your daily functioning. So for example, you know, are you able to do chores around the house anymore? Or are you able to go out in public? Are you too anxious to do that, or things like that? Okay. Now, as I said, based on the statistics, most people get approved at the ALJ level. However, if not, again, you will get a written decision in the mail, and you have 60 days from that decision to file an appeal with the Appeals Council. And when you file an appeal with the Appeals Council, you don't get to necessarily submit new medical records or anything like that. All the Appeals Council is really looking for is whether the judge made some sort of mistake in writing his decision. You can file that appeal online. You can fax it to a fax number. You can submit a letter asking to appeal. And the decision, like I said before, can take a very long time. It can take up to 2 years before you get a decision on your appeal from the Appeals Council. And the Appeals Council will do one of 3 things when they're making a decision. They can either uphold the judge's decision, meaning they just say, we don't think the judge did anything wrong, so they deny your appeal. They can reverse the decision completely, meaning they actually grant you benefits. That, however, is a little less common. If they're going to grant you some sort of favorable decision, more likely what they're going to do is what's called remand it back to the ALJ. And that means canceling the ALJ's decision as though it didn't happen, basically, and sending your case back to the ALJ to do another hearing, to do a do-over, with instructions to the judge on how they need to do better at the next hearing. Okay. Now, if you get denied by the Appeals Council, however, you then, like I said before, have the option of filing a lawsuit against the Social Security Administration in federal court. So you're basically suing the commissioner of Social Security. Again, this must be filed within, a complaint must be filed within 60 days after receiving the unfavorable Appeals Council decision. And again, same thing. The federal court judge will do one of 3 things. They will uphold the judge's decision saying you didn't do anything wrong. They will reverse the decision and grant you benefits, or they will cancel the judge's decision and just send it back to the same, usually the same judge. Sometimes it'll be a different judge depending on circumstances. Send it back to Social Security to do another hearing. And again, it takes a long time. It can take 1 to 2 years after you file your complaint for a decision to be made by the district judge. Now, what's unique about federal court appeals is that while your appeal is pending in federal court, you can also file a brand new application with Social Security. So theoretically, you know, sometimes people will get approved on their new application and they will get their monthly Social Security benefits. But then they still have this case pending in federal court, which, let's say, you know, theoretically you win your federal court appeal. This means that you then get even more money. You'll get more back pay for the time that you were waiting for this appeal to go through. So you can't file a new appeal at the previous stage, or I'm sorry, you can't file a new application at the previous stage when you appeal with the Appeals Council. You can only decide one or the other, whether you want to do a new application or do an Appeals Council appeal. But if you're denied at the Appeals Council and you go with a federal court appeal, then you can appeal in federal court and file a brand new application at the same time. So that kind of sums it up for the adult SSDI and SSI program. I want to spend a little bit of time, not too long, talking about the children's SSI program, which we have at Legal Aid. Now, legal aid is unique in that we are the only ones in San Diego with a program that is specifically dedicated to SSI for children. And we have attorneys in our program that specialize in doing the children's SSI. And this is important because, you know, SSI is the only source of federal income that is targeted to families who are caring for children with disabilities. And that can be sort of a lifeline for some of these families because it's assisting, you know, severely impaired children and their families who by definition are low income, because these families are often facing higher costs and more demands on their time and their resources because they have to care for children with severe disabilities. Now, as far as eligibility for the children's SSI program, it's much like the adult requirements as far as, you know, you have to have a severe disability. Of course, the main difference is that you have to be under 18, obviously. And there are still, you know, income and resource requirements, limits, but it's just the parents' income and assets that are evaluated for eligibility instead of the actual child's. The definition of disability for children is much like the adult definition, but it just specifies, you know, more specifically that they must have marked and severe functional limitations, which both have specific meanings under Social Security law. Again, as with adults, children's cases must be supported by objective medical evidence, so the kids' medical records. Oftentimes you're gathering non-medical records as well to establish what the kids' functional limitations are. So you're looking at, you know, special education records if they have some sort of intellectual disability, such as individual education plans, regional center records, and regional centers for people with, you know, intellectual disabilities, you know, statements from the kids' caregivers, all of that can come into evidence. And as far as the actual procedure for applying for children's SSI, it's basically the same. It's the same as adults. Okay, so that's all I wanted to say about that. Now, of course, everything that I just talked about right now is, you know, assuming that we're not in a pandemic. However, we are right now. So COVID-19 has definitely had an impact on the procedures for applying for SSI and SSDI. So online services continue. You can still file an SSDI application online. You can still check your application status online. You can still schedule phone appointments to apply for benefits. However, the in-person component is suspended. The local offices are closed, so you can no longer go in and visit a Social Security office in person for help. But they do have staff, local staff working, usually working from home, who are providing critical services by phone, fax, or mail. And what they're doing is they're kind of prioritizing critical cases right now. So critical cases means, you know, if the claimant is homeless or has a terminal illness, they're going to put those ahead of the other Social Security cases. Also, there are no in-person or video hearings right now because the hearings offices are closed to the public. And they're not doing video hearings because, like I was kind of talking about before, the video hearings still require the claimant to actually go to the local office and sit in front of their TV screen. So right now, only phone hearings are being conducted. The claimants, though, if they really don't want to do a phone hearing, at this point, you have the option of opting out of a phone hearing and instead postponing your hearing date to a later date, to hopefully a time when you can appear in person when the office is, hearing office is open again. Now it should be noted that judges technically do have the power to compel you to attend by phone, but typically, and at this point, they're still giving claimants the choice of whether or not they want to appear in phone or just postpone their hearing. And also consultative exams are being suspended. So those are the exams that I was telling you about before, where Social Security will send you to one of their doctors to examine you and issue an independent report. So that's kind of delaying cases right now, because if they feel that you do need to have an exam done, well, they're not being done right now. So. All right, well, I guess I'm going to turn it over back to Veronica now to wrap things up.
Okay, I'm back. Can everyone hear me all right?
I can.
Okay, great. So I know we're about 5 minutes left into our program, so I'm gonna go over, as quickly an overview of the type of services, Social Security Advocacy Program services that we have through Legal Aid Society of San Diego. So our office provides free legal assistance with Social Security related problems. Generally, you may be eligible for our services if you have a mental or behavioral health condition or receive general relief benefits. And our staff of advocates and attorneys help with all aspects of the claims process. So we file initial applications, reconsiderations, and we also assist people with continued disability reviews. Due to the sake of time, we didn't go into this, but even after someone is approved for benefits, Social Security may do what's called a continuing disability review to see if you still meet Social Security's definition of disability. So we help out with that. We help out with cases where Social Security, says, we think you're no longer disabled, so we're going to terminate your benefit. So we help people with that as well. And like Dana described, we represent clients at administrative law hearings. We represent clients before the Appeals Council and also in federal district court. And we have represented clients all the way up to the Ninth Circuit Court of Appeal. You can access our services by giving us a call. So at the end, again, I'm going to give you our telephone number. And although our offices are closed to the public right now due to COVID-19, we're still fully staffed and still helping people file for Social Security. So we're working, still working with people to help them obtain benefits by doing it in a way that is, in compliance with all of the social distancing requirements and precautions that we need to take right now. And in addition to Social Security advocacy, Legal Aid Society of San Diego helps out with a wide array of other legal problems, okay? So we have a housing team that helps with housing discrimination and eviction cases or unlawful detainer cases. We have a consumer center for healthcare, education, and advocacy. So we help people with accessing behavioral health and physical healthcare benefits. We also help individuals obtain public benefits like CalWORKS, IHSS. We have a tax team, a consumer protection team, and we also have bankruptcy clinics. We have an immigration team and a family law team. And again, several of the clinics that we operate right now in person are suspended, but we are still providing legal services through other means. So just as a disclaimer, all the information that we've shared so far, obviously can't include all the federal laws, regulations, or policy directives. We're just, hoping to provide a general overview of these topics. And this is also the way that we're going to approach the Q&A, as we, every question is fact specific, and, we can't actually give a legal advice, but kind of provide general information about these topics. And so with that, I'm going to go ahead and display our contact information screen, and we could go over some Q&A, okay? Because we've got a couple of questions so far through the chat box. So I can go ahead and answer them. So if, no, we're at 1 o'clock right now, but we could take some time to just answer a couple questions. And again, please feel free to call us if you have, you know, additional information if we're not able to get to all of the questions today, because it's already 1 o'clock. So the first question I'm going to go over generally, so we have 2 chat boxes. So let me open, and I thank you all for your patience here, because there's a few moving pieces here. So so I actually just remember the question from the top of my head. I can't for some reason pull it up right now. It might be just due to the view that I have, but the question had to do with an individual who had been in a relationship for 33 years, but they're not married, and they're wondering whether they might still be entitled to SSDI by virtue of their spouse's work history. And so generally, SSDI is, there are disabled widow and widower's benefits for people who are married and the spouse you know, passes away. Even if someone's not technically married, the marriage might be considered a common law marriage, and Social Security does recognize that. But again, it will depend on the facts. Like, I can't say for certain whether this, you know, scenario will result in you being eligible for benefits, but they do recognize instances in which individuals aren't formally married, but have been you know, together for some time, regarded each other as, you know, spouses. And the timeline to apply for disabled widow or widower's benefits or survivor's benefits is 2 years after the date the spouse passed away. So hopefully that provides some guidance. Again, you know, give us a call if there's any other questions about that, okay? And then I'm going to see if I could pull up another question.
I have them pulled up, Veronica.
Okay, sure.
Okay, so I'm not sure which one of these came first. Oh no, wait, here we go. The next one it looks like was, I've worked at least 1 quarter since age 21. Is this an average or looked at on a year-by-year basis? For example, for individuals who attended grad school and didn't work until 26 or 27, would they not qualify?
Right. So, so the information that we provide in the presentation was pretty general. The number of work credits that you'd need would really, it depends on the age in which you became disabled. And so Social Security will calculate the number of work credits you needed prior to that date. So conceivably, you might still be eligible, you know, if you didn't work till 26 or 27, but again, it might, it'll depend on further information and facts. As a general rule, our office, we always submit applications for SSI and SSDI because we don't want to count anyone out, and people may not actually have really in-depth understanding of the extent of their work history. So there are instances in which people are pleasantly surprised and find out that they're eligible for SSDI. So I wouldn't kind of count yourself out, still apply. And, you know, again, you're welcome to contact our office, you know, to get further guidance about your potential application or this specific question. But again, the credits that you would need, which will be based on your work history, will depend on the age in which you became disabled. So, okay, and so I see another question. How does aging out of foster care at age 21 impact SSI/SSDI decision? I guess I'm not sure. I don't think it would have an impact on the actual decision. So, you know, again, if there's maybe more facts or information you want to provide about the question, you're welcome to contact us. But I can't imagine it having a impact on the decision. You know, what they want to look for is your diagnosis and whether there's supporting objective medical evidence and a treatment history that shows that it's severe and that it's lasted 12 months or that it's going to last 12 months. Do you see any others, Dana?
There's 2 more in the chat box. Do you want me to read one or?
Oh, I went over those, the one at 12:20, the one sent at 12:20 and the one
No,
sent
no,
at
no.
12:59?
In the, not the Q&A box, the chat box. There's one.
Okay. All right, let's see.
About childhood.
And again, I apologize to the attendees. I don't know where my chat box went. Oh boy. Did you want to go ahead and
I'll go.
Yeah.
Do you want me to read it? Okay. So this one says, I am an SDI recipient. Should be good for 3 years. Haven't heard anything to the contrary, even though it's already been 3 years and I haven't been called about reinstating benefits. What should I do? Now it says SDI. If you're talking about state, SDI normally stands for state disability insurance. So if that's what you're talking about, one, we don't deal with state disability insurance. If you're talking about actual Social Security disability, yeah, oftentimes it takes them several years before they get to reviewing your file, whether it qualifies. So basically you just need to make sure that you're still treating with your doctors and following through on treatment, so that when they finally do get around to reviewing your case, then you can still have medical records to show them.
Right. Yeah, I agree. It's important just to continue with your treatment and, just keeping track of the providers that you visit and frequent. So when they do contact you, if they do, to conduct a continuing eligibility review, you're able to provide them with the information that they need in order to evaluate your case, because that is something that we see from time to time, that some people will stop treatment once they get approved, and then by the time they go under review, there are no records to demonstrate that they're still having physical or mental problems that are impacting their life, and to the point that they're unable to work. So it's important to stick to treatment. I see another question. Is there a wait list to receive assistance or legal representation if qualified? We don't have a wait list. So so that's that. I would just encourage you to call, because we, while it is free, we do have some requirements that we need to ensure prospective clients meet in order to qualify for our services. And then I have a chat box question. Could a 19-year-old diagnosed with Asperger's syndrome be eligible for SSDI? And again, generally, yes, someone with Asperger's who is on the autism spectrum, that is something, a condition that could be disabling to the point that they'd be eligible for Social Security. So with just based on that information, just generally, yes, people with Asperger's, depending on the severity, could conceivably be eligible for Social Security benefits.
There are a couple more in the other box. I don't know if we have time to address them or what.
Oh, here we go. I have, okay, I see these boxes. Okay. All right, let's see. If it's okay with Lisa in the law library, I'm happy to keep going a bit more.
Yes, that's absolutely fine if you have time. I was also going to just type into the chat box for anyone that you don't get to their questions. They can feel free to contact you at your contact information there on the screen as well. So
okay, yeah. Well, let me see. I'll keep going here. All right. So there's one question about, again, having a lawyer but wanting to potentially use our office. Again, you're free to contact us to see if that's something that you can, that you'd be eligible for. And regarding the, there's a question about children's Social Security and whether Social Security considers the assets of the guardian. I don't, generally they will consider the assets of a legal guardian, but again, we might need to get some more information about kind of the nature of the guardianship in order to answer that question fully. So I don't mean to keep pivoting people to our phone number, but just to be able to give better advice. Generally they would consider the assets of the guardian, but again, we need to learn more about the nature of that relationship between the guardian and the child.
Yeah, because there are always various factors that are going to play into
Right.
what the correct answer is. So,
okay, and then there's a question about, does abuse have an impact on an SSDI case? So I'm gonna maybe figure out how the best way to answer this is if someone is experiencing, physical or mental health symptoms that's resulted in a diagnosis, for instance, depression, anxiety, PTSD, or any other sort of mental or physical disorder that's the result of abuse, it, the way it would impact an SSDI case is that it would provide evidence, that the problems they experience or the abuse they experience impacts their ability to work. So I think that's the best way I could answer that question.
yeah.
Do you have anything else to add, Dana, or anything that?
Let's see here. I think we answered all the questions, and yeah, I agree with you on how you answered that last one. Yeah, it's not always so much the source of, any mental or physical issues that you have. It's the impact that your disabilities have on your ability to work. So yes, oftentimes abuse does provide the context for Social Security understanding, how severe your symptoms can be. And even like sometimes, like with PTSD, there's a requirement that you have experienced some type of, violent trauma. So yeah, that can be relevant. But yeah, it's mostly to do with the effects that things like that have had on you. So yeah.
Okay, I'm gonna have one more look at the chat panels and just see if there's any questions that have come up. Okay. Let's see. Okay, maybe some more. Let's see here. Oh, well, I think that we've, okay, so
I guess that's it.
there is one question about, are there any eligibility requirements to attain legal assistance with Legal Aid Society? So again, our program serves people with mental or behavioral health conditions, and also individuals that are receiving general relief. So if you want to find out more about whether you're eligible for our services, just please give us a call and we'll be able to do intake and eligibility screening, okay? So again, our numbers 877-534-2524, and we have 3 offices, one located in Southeast San Diego, not too far from the Euclid Trolley Station. We also have an office in Midtown, right off Washington Street, not far from the Washington Street Trolley Station. And there's also an office in Oceanside in North County, and it's not very far from the Oceanside Transit Center if you're relying on public transportation. But again, a lot of our offices are closed to the public, but you're welcome to give us a call because we're still working with people and helping people with their legal problems. So please don't hesitate to contact us during this time.
Yep. All right, is that it?
Yeah, so Lisa, I think we'll wrap it up, and thank you so much for spending the lunch hour with us, and hopefully we'll return for another presentation, okay?
Thank you, guys.
Thank you so
right.
much.
Thank
Thank you. For those of you who are still on, this is Lisa from San Diego Law Library. We'd really appreciate it if you took our survey once you sign off. Thank you.
Thanks. Bye.